SMSF Law, Family Estate Protection Planning. Rule number 2, have a proper TTW, a Testamentary Trust Will. Hi, I'm Shane Ellis, the Managing Director of Equity Protect and SMSF Law. I'm a senior consulting lawyer specialising in self-managed super fund estates, family estate protection planning, asset protection structuring, and business structures. If you would like further information in relation to my qualifications and what I do around Australia, please refer to the introductory presentation in this series. Again, here's the royal pardon on screen. The information that we're providing to you is by way of general information only. If you would like our assistance with your specific facts, please contact us at SMSF Law, the contact details of which are on the last slide in this presentation. Your will should only ever be a testamentary trust. What is a testamentary trust will? A will is a legal document that specifies how you want your assets to be used and distributed when you pass away, when you die. A will with one or more trusts that commence upon the death of the person making it is called a testamentary trust will. We call it a TTW. It is called a TTW because the trust within the document arises from the last will and testament of its maker. Last will and testament, testamentary trust. The person running the TTW for you are called your trustee and executor, and they are guided on the running of your testamentary trust will via a document that you create called your letter of wishes. The people who receive the benefits from your testamentary trust will are called your beneficiaries. Who should have a TTW? Anyone over 18 years of age should at the very least have a basic will and enduring power of attorney. A TTW should be part of any person's family estate protection planning who has assets they wish to leave and share with their family, their loved ones, or wish to leave for charitable purposes upon their death. What is a trustee and executor? An executor is a person named by the maker of a TTW to carry out the directions of the TTW. A trustee is a person who holds property or a position of trust or responsibility for the benefit of another. Your trustee and executor accordingly holds the property and assets left by you as maker of the TTW and carries out your directions for their use and distribution upon your death. Who should be your trustee and executor? Only a person or people you have the utmost trust in. Now I need to repeat that. Your trustee and executor should only ever be a person or people that you have the utmost trust in, because you are leaving all of your assets to their care for distribution to your beneficiaries. Why have a TTW? So you can name the guardians of your infant children, to create a trust that protects your legacy and those to whom you will leave your legacy from themselves and from the impact or influence of others. It's easier preservation and control of your assets when you pass away if they flow via a TTW. You also will have greater avoidance of family disputes because things are set out clearly in the letter of wishes and in the TTW. A TTW also provides great tax advantages because children receive their legacy, their benefit under the testamentary trust will at adult tax rates. Now I want to discuss with you what I call the tennis coach dilemma. Let's say mum and dad are going along quite well in life and they have a mum's and dad's will. Unfortunately, dad passes away and all the assets then travel in favour of mum on the outside of the firewall. So mum's got full control and ownership of the assets that she had in her name and also those that she's received from dad's will. Now, shortly after that, mum strikes up a relationship with the tennis coach and they're going along all fine and things blossom. Then after a period of time, mum passes away. The risk of all the assets being on the outside of the firewall and flowing straight through to mum, that they could possibly be left to and go down the bloodline of the tennis coach to the exclusion of mum and dad's own bloodline. Now let's have a look at those same set of facts where we've got a testamentary trust will, and that testamentary trust will is behind the firewall. So again, dad passes away and mum's assets remain as mum's, but dad's assets under his TTW flow into the testamentary trust will behind the firewall. The trustees and executors have got control of that and are able to assist mum with the running of her affairs. So the relationship blossoms with the tennis coach, but in this particular instance, if mum was to pass away, there could still be the risk, if she didn't have a TTW, of her assets going in favour of the tennis coach. But those that remain back in the dad's TTW are able then to be able to pass down the bloodline for the benefit of the kids. So you see the greater protection is afforded there by a testamentary trust controlling the assets as opposed to the individual having full ownership with the assets remaining on the outside of the firewall. Now let's take this one step further and involve the kids. Again, if we've got a basic mums and dads will, and mum and dad were to pass away, and they're on the outside of the firewall, so all of their assets go directly to the kids, if the kids are subject to any misadventure at that point in time, such as bankruptcy, in a family law dispute, or they're likely to be abusing things such as drugs or just can't control their finances, then all the assets could be lost. But again, if we have a look at those facts, and upon mum and dad's passing, the assets were to fall into the testamentary trust, the trustees and executors of the testamentary trust can retain control of the assets until such time as a child's out of bankruptcy or the family law dispute has been resolved. Or in relation to the substance or financial abuse, the trustees and executors can again maintain control of the estate until such time as the child is clean of the drug addiction or is gone off to Gamblers Anonymous and is able to properly control their affairs. Why have a TTW if you have a self-managed super fund? Well, with most deeds, upon your death benefits within the self-managed super fund are distributed by your trustee under the fund in accordance with your binding nomination, if you have one, or if there's no binding nomination, in accordance with that trustee's desire. So we'll see in the next presentation in relation to self-managed super fund wills some of the dilemmas that arise if you don't have proper protection in relation to your self-managed super fund estate. Now, with the deed that we use, on your death, your legal personal representative, usually your trustee and executor, steps into your shoes until the death benefits begin to be paid. So they have control of your affairs within the fund. They're the only party that can vote in relation to your death benefits to ensure that they go where you want them to. You maintain control of your self-managed super fund estate. And you'll see how very critical this is and how it works so very well, as I said in the next presentation. What if the trustee and executor stuffs up? A trustee and executor is accountable for their actions. They must act in accordance with the terms of the trust. They can be held liable for deliberate mismanagement, and they could be held liable for gross negligent mismanagement. They could be sued and prosecuted for their actions and can be personally liable if the trust assets are not enough to meet a claim. Accordingly, there is a lot of responsibility that rides with the trustee and executor in relation to handling your affairs. So, as previously mentioned, ensure that you select very wisely and you have the utmost trust in your trustee and executor. When should a TTW be upgraded? A TTW should be construed as being a living document that follows and reflects your life's journey. I believe that you should review your TTW each year at the time that you consider your tax to consider its currency. Further, your TTW should also be reviewed when an event requires it in your life. Such events may trigger the need to change the documentation, and also some events such as marriage or divorce will actually quash a will altogether. Circumstances such as marriage, separation or divorce, entering or leaving a de facto relationship, the birth of a child or grandchild, the change of your assets or financial circumstances, the death of a spouse or partner, a change to a beneficiary, or the incapacity, death, or desire to change a trustee, an executor, or guardian are all triggering factors where you should give consideration to upgrading your TTW. So, how do you create a TTW? It's quite simple, really. All you need to do is contact us now at SMSF Law. Here again is my email contact details, shane@smsf-law.com.au, or you're welcome to call me directly on my mobile 0414 450503. SMSF Law, Family Estate Protection Planning. Rule number 2, have a proper TTW. Have a proper Testamentary Trust Will.